Good afternoon. In our session, Althea, Daniel and I are going to talk about family members. I'm going to start talking about the continuing rights of family members. There have been quite a lot of questions so far, which is an indication of how huge a topic this is. And I will try to answer some of the questions that have arisen. So please keep putting your questions in the Q&A box. I'll start by emphasizing a point that's already been made, but I think it's so important when looking at this area on family members, which is that when trying to navigate through the various provisions, in particular Appendix EU and EUFP for family members, which I'll be moving on to, it's important to remind oneself of the provisions in the withdrawal agreement. So the definition of family members that Alan set out under Article 9, and also the scope of the withdrawal agreement, because there's likely to be situations where the rules either haven't been applied correctly or they are not compatible with the withdrawal agreement. So on the first page of my slides, I've provided an overview. As I said, Alan's already covered the withdrawal agreement. It's important to look at that when considering applications under the EU settlement scheme. And as we know, Appendix EU and Appendix EUFP of the immigration rules sets out the basis on which an EEA citizen and their family members can apply for indefinite leave to remain or enter, or limited leave to remain or enter. Now, if we just move on to the next slide, we can see that family members covers categories under the Citizens Directive. So spouses, civil partners, durable partners, or children, or dependent parents, or dependent relatives. It also covers people whose presence is required by EU citizens or UK nationals who qualify in order not to deprive them of their right of residence under the withdrawal agreement. And that includes a family member who has retained the right of residence, which I'll move on to, or a family member of a qualifying British citizen, which Daniel will speak to you about. Now, moving on, there are two, what's important to note here is the scope, exactly. The relationship with the EEA citizen must have existed before the end of the transition period, the 31st of December 2020. There have been some questions about that, so I hope that that answers that question, except for a child born to or adopted by an EEA citizen after the end of the transition period, where the EEA citizen is resident here by then. Moving on. Thanks, Alan. There are essentially two categories of leave that can be granted: indefinite leave to remain or limited leave with a view to applying for indefinite leave to remain. And in order to qualify for indefinite leave to remain, firstly, an applicant needs to meet various eligibility requirements. I've tried to summarize the main ones in the third paragraph there. They're outlined in Appendix EU, paragraphs 11 to 13. And they must not be refused under the suitability requirements under EU 15 to 16, which will be dealt with in a later session. And what's important here is that where there's a reference to an applicant completing 5 years, a continuous qualifying period of 5 years, it's cut off there, but I hope you can all access the slides. They can apply using and relying on periods of leave granted under different provisions of the Appendix EU, so under different categories. And for limited leave to remain, family members are granted 5 years limited leave to remain under EU3, where the Secretary of State is satisfied that they meet the eligibility requirements as well. There is reference as well to required evidence of a family relationship, and that also applies for those applying for indefinite leave to remain. Now, it's important to bear in mind that in the EU settlement guidance that was published on the 24th of August 2020, the caseworkers are required to take a practical approach, and where someone cannot provide the required evidence, they need to be considered with a practical and compassionate basis. And also, if the caseworker is not satisfied that an applicant meets any of the eligibility requirements for ILR, they must consider their eligibility for 5 years limited leave to enter or remain. So that's quite useful in the guidance, and is going to be, I think, important when advising clients who have been refused any leave to remain. That's the scope for challenging that. Moving on to Appendix EU FP, family permit, that sets out the basis on which a non-EEA citizen will be granted entry clearance for the purposes of acquiring leave to enter or remain in the UK. And that's in the form of a family permit. And I've provided here some examples, and it's important to bear in mind as well, as I said about the guidance, that the Home Office can check its own records as well. And so if there's a gap in the evidence, the Home Office ought to be invited to check its own records in order to show and establish that an individual has, for instance, been here for a continuous qualifying period of 5 years, as shown by the first example there. I've tried to provide an outline of the changes that are going to come into effect from the 11 p.m. on the 31st of December 2020. So if you look at the immigration rules on the Home Office website, the changes that are being brought in by the statement of changes to the rules are of course not yet incorporated in those rules. And the statement of changes is quite a dense document to navigate. So what I've tried to do here is provide a summary of the main changes. And those are 6 changes that I've identified to be the most important. The firstly is applications are restricted to the required date. And that's at the end of the so-called grace period that Ileri was talking about, so the 30th of June 2021, and that's except for applications for indefinite leave to remain where the applicant already has limited leave to enter or remain. Secondly, those who do miss this deadline, they must provide reasonable grounds why they missed the deadline, and this, I think, is going to be really significant for vulnerable applicants, for applicants as well who are struggling to apply due to the current pandemic. And there is a hope that the Home Office will be flexible. We don't yet have guidance on this, as Nina referred to earlier. And so this is a space to watch, I think. Thirdly, and this, I think, will answer some of the questions we've seen in the Q&A box, which is that the statement of changes introduce a new category for joining family members of a relevant sponsor. So what that means is a resident EEA or Swiss citizen's existing close family members who are resident overseas at the end of the transition period. So at the by the 31st of December 2020, or who are resident in the UK by that time, and they break the required continuity of that residence. So the family relationship needs to continue to exist when the family member seeks to join them in the UK. There is a qualification, they don't have to apply by the required date. There is a big however, so if we move on. Thank you. This route is restricted to those where the EEA citizen has a grant of leave to remain or indefinite leave to remain if the application is made after the 30th of June 2020. And this might create issues for those whose sponsor has a pending application, and it does raise the question whether it's compatible with the withdrawal agreement and its scope. So that is, I think, going to be an issue for applicants, and is worth reverting back to the withdrawal agreement and raising the scope of it with the Home Office if this creates any difficulties for clients. The fourth change is that there are additions to the eligibility criteria and exceptions. Fifthly, dependency needs to be assumed in relevant sponsor cases before the 1st of July 2021. Again, I think that was a question that was answered, and Althea is going to talk about derived rights shortly. And the sixth change, it's that the statement of changes introduced changes to the definition of a family member who has retained the right of residence, which I'm going to move on to now, retained rights. So in terms of the definition, we know that family members can apply for ILR or limited leave to remain by relying on a retained right. The definition is in Annex 1 to Appendix EU and in the statement of changes that I've referred to. And these are the different situations where individuals can retain their rights. So where an applicant or their family member's marriage or civil partnership or relationship has ended. I'm going to talk about that in a moment. I think that's one of the most significant changes that we've seen. Secondly, where the EEA national has died, there's a requirement that the applicant has lived in the UK for 1 year. And 3 and 4 apply to children and parents who were in education in the UK. So in cases that there have been quite a lot of questions about cases where a marriage has terminated, and I anticipated this because in my practice I have dealt with cases like that over the years. So I've provided there a summary and of the requirements, and the applicant must have been in a relationship for 3 years prior to the initiation of the proceedings for the termination of the marriage or civil partnership, and the parties must have lived in the UK for 1 year, except where the applicant has custody of or right of access to a child, or the relationship has broken down due to domestic violence. So that's quite an important exception there. Before we move on to that situation, which I'll deal with in more detail in a moment, I want to make the point as well that, and this is in the second paragraph of the slide, which is that if during the proceedings for the termination of the marriage or civil partnership, the EEA citizen ceases to be a relevant EEA citizen, they will be deemed to have remained an irrelevant EEA citizen until the termination of the marriage or civil partnership. I mention this because in 2018, there was a judgment from the Court of Appeal, which I've cited in the third paragraph there, in which the Secretary of State conceded this, that a non-EEA national can retain a right to reside in the UK and doesn't need to show that their former EEA spouse exercised treaty rights until the divorce itself, but until divorce proceedings were commenced. I think that's really important from an evidential point of view. And following that judgment, the EEA regulations were in fact amended. In a case in which I advised a client recently, He had applied under the EEA regulations because of COVID. There was a delay in determining his application, and he received a refusal in September in which the Home Office cited the previous regulations, which predated this judgment and the changes made thereafter. And the Home Office said they refused his application for permanent residence on the basis that his EEA spouse had left the UK during the divorce proceedings and wasn't exercising treaty rights. It in fact transpired that she had applied under the EU settlement scheme and had been granted status. So in fact, the Home Office could have checked their own records, but had failed to do so. So we've had to appeal on the basis that she had settled status. And so also because she had that status at the time that the divorce proceedings had been initiated, he should have been granted permanent residence as a former spouse that had retained his right of residence. So I think that's really important to look out for, because if the Home Office isn't applying the regulations that are up to date, they might not be applying the rules that are quite dense, and in particular, the changes made to those rules recently, and are going to come into effect as well on the 31st of December. Moving on, please. There have been 4 important changes made to the rules in terms of retained rights this year. 2 by the statement of changes to the rules that are dated 14th of May 2020, and one of them I've already spoken about, which is a very important change, very interesting change in my view, for victims of domestic abuse, and that is that the right is extended to family members whose relationship has broken down permanently as a result of domestic violence or abuse. And they have the continued right of residence where this is warranted, note the word warranted, by domestic violence or abuse against them or another family member. And what's important here as well is that the applicant can be the victim or a relevant family member of a victim. And previously, retained rights were limited to a former spouse or civil partner. So this, in fact, goes beyond the withdrawal agreement. I think it's really significant. And those victims will be deemed to have ceased to be a family member for the purposes of Appendix EU once the permanent breakdown occurred. Moving on to the second change, is that children and other family members have a continued right of residence following a termination of marriage or civil partnership, or as we've seen, a breakdown in the relationship. And we have the time limit there, or the timings that are relevant for a marriage or civil partnership to break down. That's not, doesn't apply to family relationships. Moving on this point, to the EU settlement scheme guidance, which is that caseworkers must take a flexible and pragmatic approach to evidence in cases where individuals apply and to exercise their right to have retained rights. And this is particularly so in this area. I don't recall a case in which I've acted where it's been particularly easy to evidence a relationship that has broken down, or the circumstances in which it has broken down. And I think it's even harder where it's a relationship rather than a marriage or a civil partnership. But one would assume that this includes evidence of an injunction or a social worker report, some kind of evidence, and the Home Office needs to be flexible about it. There's no mandatory evidence that is required. And So the statement of changes dated the 22nd of October 2020 introduced two new changes that are going to have effect from the 31st of December. The first is in the definition, which is quite dense in Annex 1 to the statement of changes, and that's that there needs to be shown a continuity of residence on the part of the applicant. If we move on to the next slide, that's defined, and that's that there hasn't been an absence from the UK for more than 6 months in a 12-month period, or the person hasn't served a period of imprisonment. And moving on to the final change, which is the one I referred to earlier, which is that for those applying after the deadline of the 30th of June 2020, one can apply by showing reasonable grounds for applying out of time. And I think that's going to be really important for those applying under this category, especially those in an abusive or controlling relationship who've been prevented from applying or accessing documents that they need to. And that brings me back to where I mentioned earlier that the Home Office needs to take a practical and pragmatic and compassionate approach. The last page of my slides includes an example, and that's based on the case that I recently advised on. And I think it's going to be really interesting to see how the Home Office applies the provisions in the rules, and also in the guidance, and the need to be practical when looking at the evidence. Thank you all for listening. I'm going to hand over now to Althea.
Hello, I'm Althea Radford. I'm a tenant at One Pump Court practicing in immigration. I am going to speak to you about two special categories of family member. First, durable partners, and secondly, people with derived rights of residence and Zambrano rights. And I'll come back to explain what I mean by that. As Claire mentioned, the provisions of the new Appendix EU are extremely dense and impenetrable. So I'm only going to provide an overview of the substance of what they provide for. You may find that when you start reading Appendix EU, you lose the will to live. But what I would say in comfort is that the basic provision for durable partners is what's set out in the withdrawal agreement. And you can always go back to the withdrawal agreement, and that would show you the shape of the situation. And broadly, Appendix EU does reflect that. I won't cover everything in my slides, as I said, because of the time, but I will give you an overview. And I think what will emerge is that there is a group of people for whom it is very important as durable partners to take action now, before 11 o'clock on the 31st of December. And there are some other people who may find that they need to leave the United Kingdom during the first half of 2021 in order to apply to come back in again. So durable partners under the Citizens Directive are a bit different from spouses. They are extended family members, and that means that they don't have an automatic right to reside based on their family situation. They have to make an application to the Home Office, and when that application is granted, at that point, they have a right of residence. What a durable partner is not defined in EU law, but it's aimed at something which deserves for respect and protection of family life. So normally a long-term stable relationship, but where the parties are not married. Because they don't have automatically rights of residence, this means it's not entirely clear when we leave the EU what do you preserve for them. You could have preserved, for example, the right to have a residence application considered. What was actually preserved is set out in the withdrawal agreement in Article 10. So first of all, you'll see that durable partners are not included as family members under Article 9. That reflects the fact that they're not family members under the Citizens Directive. but they are included in the personal scope of Article 10. But only if they were living in the United Kingdom and having their residence facilitated by the host state before the 31st of December, or they have applied for that before the 31st of December, or they were living outside the host state at the end of the transition period, but they were already in a durable relationship, and if that durable relationship continues. So what's missing there is people who are living as durable partners in the United Kingdom before the end of the transition period, but their residence is not being facilitated by the United Kingdom. That means they don't have leave to remain or a residence card in the United Kingdom at the end of the transition period. So how do these two conditions get translated into Appendix EU? Well, the requirement for a durable partner to have had their leave facilitated before the end of the transition period is reflected in the requirement for an EEA durable partner to have a relevant document. And that is contained within the definition of evidence required of a family relationship. A relevant document is an EEA residence card, family permit, or certificate of registration, which has been applied for by the 31st of December 2020, or in the case of a family permit, before the end of June 2021. It also must not have expired. There is an exception that if somebody has applied for an extension, applied for a new residence document in the period of its validity, and that application has then been granted before the Secretary of State starts to comes to make a decision under Appendix EU, then that will be permitted even though the residence document they relied on has expired by the date of decision, by the date of application, I'm sorry. So that's a narrow protection. It does mean that there's going to be problems for people who have applied to extend their residence documentation before the end of the transition period or before the end of the grace period, and they've still got an application pending. They won't be able to rely on their old document. And it also means that somebody who lets their residence card expire without applying for a new one before it expires is going to be left out of Appendix EU. The second part of the withdrawal agreement, the protection for people who are outside of the UK at the end of the transition period, that has been implemented by subparagraph B2 in the definition of a durable partner. These particular durable partners then don't need to provide the relevant document when we come to look at the required evidence of a family relationship. Now, subparagraph B2 is beautifully drafted to be as difficult as possible, but in substance, there are 3 points. First, that it covers people who have never lived in the United Kingdom as durable partners before the 31st of December 2020. Secondly, it covers people who have, but they had an alternative form of lawful leave, so not as durable partners. And thirdly, it also protects people who have lived in the UK as durable partners before, but their continuity of residence was then broken by specific events, such as an absence of more than 6 months in any 12-month period, or some supervening events. And then they haven't gone back to living in the United Kingdom after that continuity of residence was broken. So you see that protects people that weren't living as durable partners in the UK at the end of the transition period, but it also protects people who were durable partners in the UK, but they've had some other form of lawful leave. So they may have been a student or something else, but they also were in the process of developing this durable partnership. And this definition of these kinds of durable partners then feeds into new paragraph EU 11A, which allows for these joining family members to make applications even after the 30th of June 2021, as long as their durable partnership was already durable by the end of this year. You'll notice that this is actually quite a narrowly defined group of people because of the reference to the need for these people not to have lived in the UK as durable partners at any time before the end of this year, but also to have been durable partners before the end of this year, which means that if somebody's had a period of overstaying of any length of time at all while they were a durable partner in the UK, they will be excluded from this provision. And it also seems to mean that even if there was a significant break in continuity of residence, but not quite enough to satisfy the particular ways in which the Secretary of State will deem that to have been, that continuity to be broken, and that could also leave people out of this definition. And we also see in Appendix EU a codification of what it means to be a durable partner, which never existed in EU law. But we have seen, of course, before in Home Office policy, her expectation that it means that you have to have cohabited for 2 years in a relationship akin to marriage, or other significant evidence of a durable relationship. And what she means by that is there is an example in her published guidance, which is that the couple have shared custody of a child. So quite a significant indication of commitment there. But ultimately, you must always come back to what a durable partner means under the withdrawal agreement, which is not defined. And it's worth remembering that the 2 years cohabitation in a relationship akin to marriage is not a definition in EU law of durable partnership. 2 years cohabitation is evidence of the durability of a partnership. I very much doubt that will be the approach that the Home Office takes, but we may need to force her to look at it a little bit more flexibly. The partnership also has to have existed before the end of this year, and it also must have been durable by the end of this year. That is also what it says in the withdrawal agreement, durable, already durable by the end of the transition period. What does that mean? Well, the Home Office is likely to interpret that to mean that you have evidence of cohabitation for 2 years before the 31st of December, or that you have significant evidence of durability dating from before the 31st of December. But she might not be right about that. One might say that a relationship which has lasted for less, or has had cohabitation for less than 2 years, but which continues after that date for much longer, has proven itself to be durable now at some point in the past. And durable meaning having the capacity to endure. And so you can look back in time at a relationship and say, well, it was durable in the past, we just didn't know that yet. I've set out in my slides a table which gives you the deadlines for applying for durable partners. So you can have a look at that in your own time. And then I'd also like to look briefly at the temporary protection regulations as they apply to durable partners. And because there is an impact of the fact that durable partners are extended family members under the Citizens Directive, and therefore they need to have a grant of residence before they are lawfully residing in the UK under the EEA regulations. Under Regulation 3.6, they are family members, but under Regulation 6, they won't be relevant persons unless they are either lawfully resident in their own right, i.e. they have residence documentation already, or they are a family member of somebody who has lawful residence under the EEA regulations, but that excludes people who have already got status under Appendix EU. So rather counterintuitively, that means that an undocumented durable partner of an undocumented but lawfully residing EEA national is protected by the grace period, but the undocumented durable partner of a settled EEA family member is not protected. I've set out some examples of how these regulations would apply to different scenarios. The first example which I'm giving is a very simple example where you have a durable partner living in the United Kingdom. They've been durable before before the end of this year, the Italian national partner has settled status, but the third country national already has an EA residence card. Their situation is quite straightforward. They can apply for pre-settled status under paragraph EU 11, as long as they do that before the 1st of July 2021, and also before the residence card expires. The second example is a more difficult one. Here you have also durable partners who've been living in the United Kingdom for some years. Their relationship is already durable. But the difference is that the third country national has no documents and no other status. Their partner, they are definitely a family member. They've got a durable relationship. The partner is lawfully in the United Kingdom with settled status. So we can assume also they've been exercising treaty rights, but they don't have a relevant document under the required evidence of a family relationship. Well, can they get a relevant document? Well, they can get one until 11 o'clock on the 31st of December 2020. It's the application date for that relevant document that matters, not the date that it's issued. But if they miss that deadline, they're not going to be protected by the temporary protection regulations because of the fact that the French partner already has their settled status. And they're not a durable partner under subparagraph B2 because the third country national has been living in the United Kingdom as a durable partner, but doesn't have a leave as a partner. And that means that they can't apply as a joining family member under paragraph E, new paragraph EU 11A. The third example I've given is exactly the same situation, but where the EEA partner has not yet applied for settled status. They are therefore protected by the temporary protection regulations. If they miss the deadline on the 31st of December, they therefore have another option. They can continue to apply for documents under the EEA regulations. However, if they apply for a residence card in January 2021, it will not be a relevant document. That's because it hasn't been applied for before the 31st of December. They could, however, leave the United Kingdom and apply for a family permit because that would be a relevant document as long as it's applied for before the end of June 2021. A fourth example I've given is partners who've been living abroad for 3 years before now. And the French national, has moved to the United Kingdom in 2020 and has pre-settled status. Their third country partner has just joined them with a visit visa. And now they want to know what they need to do. Well, they can apply for pre-settled status under paragraph EU 11A, I think, because the third country national has not been living in the United Kingdom as a partner before the 31st of December. He has arrived in the United Kingdom before the 31st of December, and he was a durable partner in the United Kingdom at that time, but he had alternative leave, which was a visit visa. On the other hand, one cannot make an application under EU 11A as a visitor in particular, that's excluded. And so that means that the partner will have to leave the United Kingdom before the expiry of their visit visa, and then they can apply for an EU settlement scheme family permit to come back into the United Kingdom and apply for pre-settled status within 3 months of their arrival. And my final example is a couple that haven't been together for 2 years before 2020. They've only got together in March this year. The EA national has pre-settled status, and the third country partner has a valid student visa. Well, they're going to have a little bit more difficulty proving to the Home Office that they are in a durable relationship because they haven't got 2 years cohabitation, and they also don't have any other significant, well, they're going to have to find some significant evidence of durability. That could be related to their plans for the future. It could be relating to their shared finances, other big commitments that they've made together. And it also appears to be a durable partner under subparagraph B2 because the third country national has been living in the United Kingdom. He has been, we're arguing, a durable partner, but he has had lawful leave in another capacity. And he's not a student, he's not a visitor, and that means that he can apply under EU 11A as a joining family member, as long as he can prove that the relationship was durable now. And he can do that at any time before his student visa expires. So hopefully that's given you a sense of how these regulations apply to durable partners. The thing to take away from it is that there are a subset of partners who really do need to make applications for residence cards before the end of this month, because they're going to have all of their avenues cut off if they don't make that application. And essentially, that's anyone who's present in the United Kingdom as a durable partner without an alternative form of leave and currently without an EU residence card. So now I'll talk about derivative and Zambrano rights. Derivative rights fall into really two groups of people. The first are Chen cases, and these are self-sufficient children of EA nationality who are living in the United Kingdom under the EA regulations. A right is derived from them to their parents or other primary carer whose presence is needed for the EA children to remain in the United Kingdom. And such a child will be self-sufficient even if it's the primary carer who is working to support them. The second group of derived rights are the Ibrahim and Tejera group. These rights arise not from the Citizens Directive, but from an older right of the children of EA workers to enter and complete their education in a host state. And this applies where somebody has been a worker in the United Kingdom and they have a child, and that child enters education, not necessarily at the same time. And whether or not that EA worker stays in the UK, if their child stays in the UK, they have a right to stay and finish their education. And a right is derived from them to their primary carer if their primary carer is necessary for them to enter to enjoy their right to education. The third group of people are Zambrano carers, and these relate to the carers of British citizens. And this right derives from the treaty itself, the right of a British citizen to reside on the Union territory. If it is not possible for a British citizen to reside on the Union of the territory without a primary carer being there to support them, then a right is derived to that primary carer to remain with them. And a right is also derived to any other dependents of the primary carer whose presence is necessary for the primary carer to be present in order for the British citizen's presence. So these are the three groups of derived rights, which are currently dealt with under Regulation 16 of the EA regulations. Their position is covered in the withdrawal agreement. In Article 9, they are included as family members. It's a rather broad definition of persons whose presence is required by Union citizens or United Kingdom nationals in order not to deprive those Union citizens or United Kingdom nationals of a right of residence granted by this part. And I also flag up Article 24, because this is where the right to continuing education is protected. That's for the children of EA workers. You'll note that Zambrano cases are not mentioned anywhere in the withdrawal agreement. And that's because if we go back to Article 9, the rights of residence which are granted by this part are the rights of residence of United Kingdom nationals in Europe, or they are the rights of residence of European nationals in the United Kingdom. But when Britain leaves the EU, the right of British citizens to reside on the territory of the Union will no longer exist. Their right to reside in Britain will become a matter of British law and would not apparently be covered by the withdrawal agreement. This could lead to problems in the future because you're going to have people who have leave under Appendix EU who in fact don't have rights under the withdrawal agreement. And so it won't be possible to say, simply from looking at whether somebody's got residence under Appendix EU, whether they therefore have rights which come from the withdrawal agreement. And that's going to be particularly difficult because Zambrano rights, or residence with a Zambrano right, can contribute to obtaining permanent residence in the future. So somebody who's got permanent residence may have established that right by reference to periods in different capacities, including as a Zambrano carer, and such a person would appear to have rights protected by the withdrawal agreement looking at their documents. But when one looks back at the substance of their life, one discovers actually they don't have any rights in European Union law at all. And they don't have any rights under the withdrawal agreement. Under Appendix EU, people with derived rights can apply for indefinite leave to remain or limited leave to remain. And they will be eligible broadly if they have had or do have a Zambrano right to reside or a derivative right to reside in the UK for a continuous period of 5 years before the 31st of December, if they want ILR, or if they want limited leave to remain, they must be somebody who has or has had a derivative or Zambrano right to reside, and they have been continuously resident in the UK for less than 5 years before the 31st of December 2020. A person with a derivative right to reside is defined in Annex 1. They have to have been resident in the United Kingdom for a period of time, of any time, before the 31st of December. And they have to have been residing with a right under Regulation 16 of the EA regulations, which is, in the case of a person with a derivative right to reside, this excludes Zambrano rights. And there are some modifications made to the requirements which somebody had to meet under the EA regulations. One thing is that Chen carers don't have to show that the child had comprehensive sickness insurance. And also the Chen derived right is going to continue even after somebody's child turns 18. The person with a Zambrano right to reside is very similar. One looks at whether they had a right to reside under Regulation 16 before the 31st of December. And again, they don't need to show that the child still remains under 18. But Zambrano carers do have to show that they do not have any form of leave to remain in any capacity outside Appendix EU. Another category of people defined in Annex 1 is people who have had a derivative or Zambrano right to reside. And as I alluded to, this is so that somebody who's had Zambrano right to remain can rely on that to clock up 5 years towards settled status. Now, the requirement that somebody, a Zambrano carer, doesn't have any alternative leave to remain is new to Appendix EU. In Regulation 16, the exclusion was narrower. It was people who were excluded were people who weren't subject to immigration control, who had a right of abode or had indefinite leave to remain. So why has the Secretary of State narrowed eligibility here? Well, she's provided some guidance in her EU settlement scheme Zambrano guidance. And she's referring here to the case of Patel, in which the Court of Appeal said that the Zambrano right can't be regarded as a backdoor route for people who have failed to apply for leave to remain under Appendix FM. And the guidance also incorporates the question of whether somebody would be whether the carer has another form of leave into the broader issue of whether the child would be required to leave the United Kingdom if the carer had to leave the United Kingdom. The Secretary of State's logic there is that if the carer is in fact not required to leave the United Kingdom, she doesn't need to answer this question, which may remind you a little bit of how she dealt with Part 5 of the 2002 Part 5A of the 2002 Immigration Act, and that approach, of course, was rejected by the Court of Appeal with regard to our domestic law. I would argue that the question posed in a Zambrano case is a hypothetical one: is would the child have to leave if their carer was required to leave? And it's therefore irrelevant whether or not that the carer has another form of limited leave. But that's probably something which is going to have to be litigated over. The other main feature of Zambrano and derivative rights under Appendix EU is the requirement for there not to be a way that the child can remain without their primary carer. And you're looking there at alternative care arrangements on which there is some quite substantial guidance in the EU settlement scheme, person with Zambrano right to reside, and also some similar document for person with a derivative right to reside. When you have a child, you're mainly going to be asking, first of all, is there another parent? If there is another parent, there'll be an assumption that they are suitable to care for the child, and your applicant will have to show that they are not suitable, either because they don't have leave to remain themselves or for some other specific reason. Lack of financial resources or a lack of willingness alone will not be sufficient. They'll also look at whether there's another direct relative. That'll be limited to people who've actually had direct contact with the child before, and have shown a willingness to care for them. And then there's different requirements for adults. Obviously, there's going to be an assumption that adults can care for themselves. But if there is strong evidence that they need care, again, the Home Office will be looking at direct relatives or a legal guardian. And they'll also be considering whether a local authority care could be provided, or even private care, so that the applicant doesn't need to be in the United Kingdom to support them. So that's the end of my section. I'm going to hand you over now to Daniel Grütters, who's going to talk to you about Surinder Singh, returning British residents.
Thank you, Althea. Good afternoon. I'm Daniel Grütters. I'm a barrister specializing in immigration and housing law. As Althea said, I'm going to briefly talk to you about the Surinder Singh route. I realize that we have about 16 minutes left in this session, and obviously we want to have some time for questions, so I'll try to speed it up. I'm going to talk about the original basis of the route, its absence in the withdrawal agreement, and its continued existence after the end of the transition period. So first, then, quick refresher. The Citizens Directive, of course, is created to protect the free movement rights of EU citizens, and it recognized that those rights can only be effective if family members of EU citizens were also given the right of entry and residence. But the Citizens Directive only dealt with these rights when an EU citizen is exercising their right of free movement. So in response, the Court of Justice developed 3 exceptions, and the Surinder Singh route is one of them. In that judgment, the Court of Justice held that an EU citizen might be deterred from using their right of free movement if, upon returning home, the conditions were not equivalent to those which they would enjoy in another member state. So in turn, that EU citizen, when returning home, after having exercised their free movement rights, must enjoy the same rights of entry and residence as would be granted to them and their spouse if they chose to enter and reside in another member state. So for a UK citizen returning home after having worked in another member state, their spouse should enjoy the same rights of entry and residence they would get in another member state. So the EEA regulations gave effect to this route in Regulation 9. And essentially the approach is that if the British citizen meets certain conditions, they and their family are treated as if, or they are treated as if they're EE citizens, and their family can derive rights from that. Under Regulation 9, the key condition is whether they created or strengthened a family life with a third country national during what's called genuine residence. And Regulation 9.3 then sets out factors to be considered in what was genuine residence. Now, one of those factors was said to be whether the center of the British citizen's life transferred to the EEA state. However, in Set A Afghanistan, the upper tribunal reviewed the relevant treaties, directives, and case law, and found that there wasn't really a basis for that requirement, which is something that we will see reflected in the changes in a moment. So secondly, then, the route under the withdrawal agreement. In a nutshell, as Althea already referred to, the withdrawal agreement seeks to protect the rights of EU citizens in the UK and UK citizens in the EU. Of course, the Surinder Singh route, when exercised by UK citizens and their family, protect the rights of UK citizens in the UK. And that means, similar to the Zambrano carers, they're not included in the withdrawal agreement. And simply put, there's just nothing stopping the UK from granting or expanding this category of rights to its own citizens and their family. And however the UK decides to grant, expand, or restrict those rights, it's a matter of purely domestic law, and so it's not included in the withdrawal agreement. I quickly just want to mention the Citizens' Right Application Deadline and Temporary Restriction EU Exit Regulations. So they basically ensure that Regulation 9 in an amended form continues to have effect during a grace period. That period, as mentioned by Larry, runs from the IPA completion date until 6 months later on the application deadline. Citizens' Right Regulation amend regulation effectively in 2 ways. And I've listed 3 Roman numerals, but Roman numeral 1 and Roman numeral 3 essentially deal with the same thing. That means that after IP completion day, a returning British citizen will be considered a qualified person without the need to meet the requirements in Regulation 9.7. And Regulation 9 is also amended to remove the center of life factor, which reflects the conclusion of the Open Tribunal in ZA Afghanistan. So Appendix EU then, so the more generous approach that we see in the regulations are also seen in the appendix. So family members of qualifying British citizens are eligible to apply for limited or indefinite leave to remain, as the case may be. And essentially, a qualifying British citizen is a British citizen who has returned to the UK and before IP completion date satisfied the criteria in 9.2, 9.3, and 9.4a. So quickly, those conditions are that the British citizen was residing in an EEA state as a worker, a self-employed person, self-sufficient person, or a student, or so resided immediately before returning to the UK, or the British citizen has acquired the right of permanent residence. Further means that the family member and the British resident resided together in the EEA state and that their residence was genuine. Regulation 9.3 sets out the factors to consider whether residence was genuine. And then Regulation 9.4a deals with the provision that prevents the abuse of the provision. So if the residence was used to circumventing immigration laws, then it cannot be relied upon. Noteworthy here is that Regulation 9.4b, which excludes extended family members, is not included in the criteria. Now, the important distinction that's made in Appendix EU is between relationships between British citizens and third country nationals, which were formed either before withdrawal or after withdrawal. If the relationship was formed before withdrawal, then the deadline for British citizens to return to the UK for the family member to qualify is 11 p.m. on the 29th of March, 2022. However, if the relationship was formed after withdrawal, then the deadline for British citizens to return to the UK for the family member to qualify is 11 p.m. on the 31st of December. And that's all from me. I believe that Claire, Althea, and myself are now going to take some questions.